Hello, this is Grant Hughes of Grant Hughes Investigates on YouTube. As you're aware, attorneys Andrew Baldwin and Brad Rozzi were removed by Francis Gull, the judge in the murder case of Richard Allen, who is accused of, and I believe is the killer of, Abigail Williams and Liberty German back on February 13th, 2017. So we know that Brad Rozzi and Andrew Baldwin were removed. However, the Supreme Court of Indiana put them back in, mainly because of two things: Richard Allen's desire to have them as his attorneys, and also that Judge Francis Gull, did not have a hearing where she was open to the idea, through arguments, that they could possibly remain on the case. Instead, Fran Gull had Rozzi and Baldwin come into her office and basically gave them a choice: either be publicly humiliated, because they deserve to be humiliated based on the information and the behavior that the two attorneys, Baldwin and Rozzi, who I consider to be absolutely embarrassments to the law profession. That's my opinion, of course. But she gave them a choice, and the choice was you could either resign. She didn't say that specifically, but let them talk about it. So they withdrew from the case, and they weren't publicly humiliated because the information would have came out and the judge had already made up her mind. Now, what she should have done was had the hearing, putting out the humiliating information, and didn't let them know that she'd already made up her mind. That's what she should have done. Because I think the information that was put out in rebuttal. So after Baldwin and Rozzi were put back in, they thought it would be a great time to try to have Judge Gull removed because of bias and her inability to be fair towards their client, Richard Allen, because she had already tried to remove Rozzi and Baldwin once already. And then in rebuttal to that, Nicholas McClelland, the prosecutor in the Delphi case, put out the information that would have been in that hearing, or at least some of it. And it comes in multiple parts. So what we're going to do is go over those parts and see exactly why Judge Fran Gull wanted to remove them as attorneys. Number one, that both Brad Rozzi and Andrew Baldwin were appointed by this court to represent the defendant herein as public defender on November 14th, 2022. That a hearing was held on November 22nd, 2022, so this is about a week after they were appointed, to resolve preliminary matters. The same day, the state of Indiana filed a motion for an order prohibiting the parties, counsel, law enforcement officials, court personnel, coroner, and family members from disseminating information or releasing any extrajudicial statements by means of public communication, commonly referred to as a gag order. All right, so the state was wondering if they need to put a gag order in. And then the court took the state's motion under advisement, but in an in-chambers conference, defense counsel Brad Rozzi and Andrew Baldwin refused to agree to the state motion, stating such an gag order, was unnecessary because they had no intentions of discussing this case in the public. I mean, just two upstanding citizens defending a client, and boy, they weren't gonna talk about it in public anyways. All right, so this is on November 22nd, and then just 9 days later, or 10 days later, on December 1st, 2022, the defendant put out a press release, meaning Baldwin and Rozzi. We know that Richard Allen didn't put out the press release, okay? So it was Baldwin and Rozzi put out a press release that included extrajudicial statements by means of public communication that commented on the case to the public and to the media, including commenting on the investigation by law enforcement, the evidence discovered against the defendant, and presenting evidence that they believe proves the defendant's innocence. The information released would have been in direct violation of the gag order. So had a gag order been put in place on the 22nd, Baldwin and Rozzi wouldn't have been able to put out this information. So of course they said, oh, it's not necessary, because being the slime bags that they are, they knew that they were going to be putting out this information that would have been covered under the gag order had it been in place on the 22nd. So let's go back. The information release would have been in direct violation of the gag order that the defense would not agree to, and which the defense stated was unnecessary because they were not going to discuss this case in the public or the media. The press release is attached as Exhibit 1 in here. Anyways, right here, number 5, it says, the press release contained multiple comments of the kind presumed to have a substantial likelihood of materially prejudicing an adjudicative proceeding in this matter. That the court entered an order on December 2nd, so the very next day after Baldwin and Rozzi broke sort of a gentleman's agreement on a gag order, granting the state's motion for order prohibiting the parties, counsel, law enforcement officials, court personnel, coroner, and family members from disseminating information or releasing any extrajudicial statements by means of public communication in whole without a hearing. The order directed the attorneys not to comment on this case to the public or to the media, directly or indirectly, by themselves or through any intermediary in any form. The court reminded counsel at that time that they were bound by rules of professional conduct, Rules 3.6, about trial publicity. This order is commonly referred to as the gag order. The court commented that this order was put out in response to the press release by defense counsel Brad Rozzi and Andrew Baldwin. So the gag order was put into effect because of the blatant disregard for the agreement that Baldwin and Rozzi had to not disseminate information about the case, and the gag order was put in place. Number 7, that sometime in December of 2022, defense counsel Andrew Baldwin violated the court's gag order by sending an email to Brandon Woodhouse containing an outline of discovery, including the names of juvenile witnesses. Brandon Woodhouse is not an attorney on this case and is not involved in this case in any capacity. Number 8, that further, defense counsel Brad Rozzi and Andrew Baldwin failed to notify the court or the state of the dissemination of information in this case to an unauthorized recipient and intentionally withheld that information from the court and the state by asking Brandon Woodhouse to delete the email. So basically they were trying to cover it up. Hey, delete the email. Hey, delete the email. That this leak of information was not discovered until the state uncovered it on Brandon Woodhouse's YouTube channel in March of 2023. So this is 3 months later. So again, a person, Brandon Woodhouse, another unethical person, thought it'd be great to make public documents that were accidentally sent to him, and obviously Rozzi and Baldwin didn't take the correct steps even behind the scenes to make sure that didn't happen. Further, it was discovered that Brandon Woodhouse has disseminated the information to several other people, and his YouTube channel was viewed by multiple viewers. This dissemination of material from the case is a violation of the gag order that directly relates back to defense counsel. So there you go again. First of all, they broke the gentleman's agreement they had of not talking about the case. Then a gag order was put in place. Then even after the gag order was put in place, they disseminated information to an actual felon. Whether accidentally or not, we don't know. You can't tell with Rozzi and Baldwin. Number 10, that on February 13th, 2023, the state filed a motion requesting protective order governing discovery in an effort to prevent the defense from disseminating evidence in this case to people outside the case and or to the public. Number 11, that on February 17th, 2023, the court granted the state's motion and put into place a protective order setting forth very restrictive rules to prevent dissemination of the discovery in this case to the public or to anyone not involved in the case. So now the rules are even more strict. But that doesn't stop Rozzi and Baldwin, man. Number 12, that in October of 2023, the state was made aware by the families of the victims that crime scene photos were leaked to the public. Indiana State Police began an investigation into how the photos were leaked. It became immediately obvious that the leaked photos came from the defense team. Man, what a surprise! On September 18, 2023, the defense filed a Frank's motion with a memorandum in support. The memorandum described the crime scene in gory, graphic detail. As part of that memorandum, the defense attached exhibits that were provided in hard copies to the state and the court. Some of the exhibits were side-by-side photos that the defense created and photos of the crime scene that the defense had altered. These photos were the photos that were leaked to the public. So as you can see there, the crime scene photos that were leaked to the public were actually the supporting photographs of the memorandum in support of the Franks hearing. Number 13, that investigators were led to a podcaster who said he got the pictures from an individual that he knew. The investigation led officers to determine the podcaster got the photos from a man that he knew who got them from Robert Fortson. Robert Fortson received the photos from Mitch Westerman, who is tied to the defense. And then number 14, that on October 10, 2023, defense counsel Andrew Baldwin stated on a conference call with all parties that a trusted confidant by the name of Mitch Westerman stopped by his office to visit, snuck into the conference room where all the discovery in this case was being held, unsecured, and took photos of crime scene pictures. Defense counsel Baldwin stated that this occurred without his permission and that the pictures were stolen. Ironically, this was hours after investigators spoke to Fortson and determined that Mitch Westerman leaked the photos and he was the connection to the defense. So right here you see Baldwin is claiming that an individual named Mitch Westerman snuck into their office, basically was waiting for Baldwin, and while he was in there, stole the images, taking pictures of the crime scene photos. But that doesn't match what we're about to hear. Number 15, that the investigation by the Indiana State Police revealed that Mitch Westerman previously worked for Baldwin and was a person Baldwin trusted. In an interview with Indiana State Police, defense counsel Baldwin admitted that he voluntarily gave Mitch Westerman a copy of the Franks memorandum to review. Defense counsel Baldwin also stated that he gave the Franks memorandum to another civilian to review. The Franks memorandum and exhibits contained protected discovery information that included very sensitive crime scene photos that were leaked by Mitch Westerman. Specifically, the investigation revealed that Mitch Westerman gave the photos to an individual named Robert Fortson, who then passed them on to individuals who distributed them throughout the internet. So right here, what we're learning is that Mitch Westerman didn't actually get the photographs by sneaking into Baldwin's office. He was given a copy of the memorandum in support of the Franks hearing, and in receiving that information, it contained the photos that were disseminated. I believe what happened here is that Baldwin and Rozzi wanted to disseminate information to try to help their client by putting out the Franks memorandum. That was also put out in a nefarious way. They were not supposed to be putting that information out, but put it out on a server, and it wasn't supposed to be public, but it was made public for a brief amount of time where a couple podcasters just happened to know that it was coming out, and boom, they downloaded it, and then it was protected under the gag order after that, but it was too late. The information was out. So I believe that Baldwin and Rozzi intentionally tried to put information out there to try to sell the narrative of their Odin theory, and they thought the crime scene photos that depict Abby and Libby on the ground and there are branches on them, that they could sell the Odin theory even more. There are no antlers in the photographs whatsoever, and there are branches placed on their bodies, so it's obviously they were placed there, but they don't look like runes of any kind. Okay, now that's my opinion, but I think they wanted to leak this information, and they used Westerman to disseminate the information to different individuals by giving it to Fortson, and then Fortson is the one who then eventually distributes it to a larger group of people, and he was supposed to do it in a way that wouldn't lead back to Baldwin's office. But the investigation did lead back to their office, and to protect Rozzi and Baldwin, I think Westerman had to fall on the sword, as it were, and claim that he snuck into the office and took these photographs. That's what makes sense here, because why would Westerman need to take photographs of images that he already had on his own person? He had the Frank's memorandum, and he had those photos, and there was no reason for him to be in Baldwin's office photographing the same images that he already had. Number 16, that on October 12, 2023, defense counsel Brad Rozzi submitted a letter to this court admitting that both he and defense counsel Andrew Baldwin had agreed to store the discovery in the conference room in defense counsel Baldwin's office. Further, defense counsel Rozzi admits that Mitch Westerman had access to the conference room and took the photos. Again, he wouldn't have needed to, since he already had the Frank's memorandum with the attached documents. Finally, defense counsel Rozzi admits that it was negligent on the part of defense counsel to allow Mitch Westerman alone in the office when sensitive discovery material was stored. Then, in Section 10 of that same letter, defense counsel Rozzi accepts responsibility for a lapse in security that caused the photos to be leaked, admitting to this court that they are in indirect contempt of the court's orders. That on October 18, 2023, Mitch Westerman submitted an affidavit to this court stating that he in fact went into the conference room of defense counsel Andrew Baldwin and took pictures of discovery evidence without the permission of defense counsel Baldwin. And so I don't believe this portion. Now, it could be true, but I don't believe it. And the reason I don't believe it is because, again, Mitch Westerman already had the Frank's memorandum with the attached images, and those are the very same images that were disseminated on the internet, and he would have no need to be in Baldwin's office and photographing the same images. Number 18, that investigators were able to retrieve messages between Robert Fortson and another individual that showed that Robert Fortson had detailed real-time knowledge about when evidence was submitted to the defense and the contents of that evidence for weeks before the photos were leaked. And that's absolutely true. Fortson is the individual who I was made aware of who put out information that allowed me to know that the Frank's document or memorandum was going to be put out. I knew, I think 2 or 3 weeks prior to the Frank's memorandum being put out, that documents were going to be put out by the defense talking about Odinism, etc., and Fortson's name was part of it. Now, the individual who let me know about that has also communicated with, in the investigation into the leak, and were helped out in that matter. Fortson also knew the actions defense took in trial preparation, leading law enforcement to believe that this was not a one-time act of one person, but a consistent leak of information and discovery in this case. Yes, and what I believe is this, is Westerman was the facilitator to disseminate information to Robert Fortson, who was then to put the information out on the internet, thus breaking the gag order. The investigation showed that Westerman would get information about the case and then give it to Fortson. There you go, right there. Who would distribute it to other individuals. 19. That investigators attempted to interview both Mitch Westerman and Robert Fortson, each of which declined. Number 20. That shortly after investigators attempted to interview Robert Fortson, he took his own life, or unalived himself, as a lot of the wackos say out there. An investigation into that death led law enforcement to find out that shortly before his death, he had expressed concerns about the open investigation concerning the discovery leak in this case, and stated to someone that if he just came clean, all this would go away. But he never had a chance to come clean because he committed suicide. Now, if you're conspiratorial about it, you'd wonder, why did he commit suicide or take his own life when, it's just like a leak of information in a case. I mean, this happens all the time. It doesn't seem that dramatic. But it seems like the information that he could have disseminated could have hurt some people's careers. So, if you're a conspiracy theorist, you sort of wonder what happened to Robert Fortson. Number 21, that a search warrant on the iCloud account of Mitch Westerman revealed screenshot photographs of conversations between Mitch Westerman and defense counsel Andrew Baldwin, wherein they candidly discussed the Richard Allen case and candidly talk about the court and the state displaying a free flow of information that is protected by the court's gag order and the order protecting discovery. So you look at how slimeballish this is, using Westerman to circumvent the gag order and disseminate information that should not be seen by the public or discussed. Number 22. That the investigation shows that defense counsel failed to secure evidence and discovery materials in this case, specifically graphic crime scene photos, which were then distributed to the public and put on the internet in violation of the court order dated February 17, 2023, and evidence supports a conclusion that the disclosure was ongoing. Now remember, the February 17th is when they really put a tight lid on the information that could be put out there. Number 23, that on October 19, 2023, and again at the hearing held on October 31st, 2023, David Hennessy, attorney for Andrew Baldwin, suggested to the court that both attorneys be sanctioned for their actions. Those sanctions have yet to be addressed. Now, here's something to keep in mind. Here is the letter that Hennessy put out. Man, it's huge on the screen here, but if you scroll down here, these are some of the things that was mentioned. There is no case allowing disqualification when an individual not part of the attorney's office or staff surreptitiously purloins information from the attorney and disseminates it without permission or the attorney's knowledge. Okay, but see, this isn't even accurate right here, because Baldwin admits that he gave the Frank's memorandum and the photos to Westerman. So there was no need for Westerman, again, for the third time that I've mentioned it, to take the photographs in Baldwin's office. All right, so this right here seems to be in contradiction to what investigators found out from Baldwin, that Westerman already had this information. So down below here, it says, Mr. Baldwin trusted a friend to respect his office space, but he didn't. He was betrayed. Since that transgression, Mr. Baldwin has kept all Delphi-related items locked in a room or a locked fireproof file cabinet. Furthermore, defense counsel has put together a plan for curative action in which no items will be left unattended for even a second in any unlocked room. I don't know. I don't believe that Baldwin and Rozzi's a little too late, in my opinion. They did everything they could to get out as much information as they can, and there really isn't much more that they could put out at this point. So, of course, it's easy to say now, oh, we locked everything up. We're so much better now. It's ridiculous. Number 24, that the state was notified in the beginning of the leak by the defense, by the families of the victims. Since that time, the state has had an opportunity to talk to the families of the victims about the photos and information that was leaked. The amount of harm and re-victimization that this has caused the families of the victims is unmeasurable and incurable. Number 25, that the press release and 2 occasions of leaked information show a trend by defense counsel Brad Rozzi and Andrew Baldwin of not being completely honest with the court, violating the court's gag order set in place to protect the integrity of the case and failing to comply with the protective order put in place to protect the discovery in this case. And there you have it. In recap, the defense team, after having a gentleman's agreement to not discuss information regarding the case, to try to avoid a gag order, they completely broke that agreement and discussed the case in public, and then a gag order was put in place. After the gag order was put in place, they sent a convict, private information regarding the case, and then that convict on YouTube put the information out there for everybody to see, and the defense team tried to hide the fact that they did that. Then a more stringent gag order was put in place, and the defense team, which isn't mentioned in here, but the memorandum in the Franks hearing was also disseminated in a nefarious way. They put it out there by pretending that they weren't aware that it needed to be protected by the gag order, even though it had sensitive crime scene information in it. So that was put out there. And then crime scene photos were released that were actually the exhibits to the memorandum in support of the Franks hearing. And it turns out that Mitch Westerman, one of Baldwin's buddies and confidant, and a person he would discuss the case with freely, he was given the Franks memorandum and supporting images, etc., which included the leaked crime scene photos. It's my opinion that Mitch Westerman merely took pictures of the same photos that he already had and disseminated them to Robert Fortson, and then those made it to a person named, I think, Mark Cohen, who then gave them out to a whole bunch of different people. And the fact that the investigation led back to Baldwin's office, it prompted, I bet there was a private conversation that we don't hear, where Westerman had to bite the bullet, as it were, and take responsibility by saying he surreptitiously took the photographs in Baldwin's office, and Baldwin had no idea. But everything in this case oozes Baldwin specifically and Rozzi being involved in the organized dissemination of information, in this case by using third parties. And I think that Judge Gull's decision was absolutely the correct decision. She just didn't go about it in the right way, thus a reversal by the Indiana State Supreme Court. As you can tell by what we've just gone over in this video, Rozzi and Baldwin are, not the two most ethical attorneys on the planet Earth. In fact, I think their behavior is disgusting. And I think people out there defending the actions of Baldwin and Rozzi are equally disgusting. All right? So thank you all very much for watching this video. I hope you have a better understanding of what the hell was going on in this case. Absolutely ridiculous. Just sort of embarrassing for the entire legal community what Rozzi and Baldwin have been doing. All right, everybody. Thank you all very much for watching. Now hit that like button on the way out the door and help support the channel. Thanks again for watching, and as I always say, until next time, be safe out there.